This is along similar lines as Senator Nelson Murray, and it's a very easy fix, I think. So this amendment would repeal the common law rule that where it is proven that a defamatory statement has been published, then general damage is automatically presumed. The right to defend one's good name in front of a jury is of course fundamental, but we must accept that something has gone wrong when retailers are facing legal actions for what are manifestly non-defamatory statements. So asking for a receipt, refusing to accept counterfeit currency, asking for ID when selling alcohol, none of these situations should be seen by businesses faced with defamation cases. And we know it's happening because I've been contacted by small to medium enterprises all over the country about this, and they're bearing the brunt of this flawed system. Retail defamation was originally to be tackled under the general scheme for this bill, but these provisions seem to be dropped by the government. So this amendment proposes to pose the question, why is defamation alone among civil wrongs in having a presumption of general damage and does this not then encourage litigation? Our current system presumes general damages when defamation has been shown to take place. So general damage is to be contrasted with special damage, which means specific financial loss or actual harm, which would need to be proven in evidence. So in contrast, general damage refers to non-economic reputational damage, for example, like impact on mental health. And the current law, though, presumes that general damage flows from every defamatory statement without the need for proof. So this means that it's not necessary for people taking frivolous, exaggerated, unfounded cases as it stands that actually can prove any loss or harm. So by changing the presumptions, we can help to ensure that our small to medium enterprises are protected from the sort of retail defamation which has become all too common in recent years. So abolishing the presumption of general damage would not deter litigants in genuine cases where it would be straightforward to produce witnesses as to the effect of the defamatory publication on their view of the plaintiff. Therefore, would this amendment, this simple fix, not tackle the serious challenge facing our small businesses, particularly in the retail sector, without in any way undermining the existing protections individuals enjoy under defamation laws?
Well, no, anyone else? No. Anish on Ara.
Yeah, thanks very much, Cahir. I want to thank Senator Nelson Murray, Senator Keoghan and Senator Cosgrove for their amendments. Obviously, Senator Nelson Murray has withdrawn her amendment, but it is very much in line with the general thrust of the other amendments that have been put forward by Senator Keoghan and Senator Cosgrove to a lesser extent. Can I just start at the outset by saying that defamation actions obviously vary in terms of their seriousness, their impact, and their, their nature. In many respects, they're similar to personal injuries actions. You can have a very minor personal injuries action where somebody trips over and sprains their knee. Similarly, you can have extraordinarily serious personal injuries actions. Child delivered through negligence at birth and suffered life-changing injuries for the whole of his or her life. So there is a variety in terms of defamation actions, just as there is in terms of personal injuries actions. Many of the motivation behind Senator Nelson Murray and indeed Senator Keoghan and Senator Cosgrove's amendment was the position of retailers. And it is the case that retailers have been subjected to inappropriate defamation actions. That's why I've put into this a specific statutory defence for retailers that never existed before, and that will, I believe, be of great benefit to them. However, we need to recall that defamation goes beyond just retailers. And we also need to reflect on, I suppose, what was reflected in the previous debate, the right to the good name of the individual. That's one of the rights that has to be balanced, and the other is the right to freedom of expression. We have seen in the past very serious examples of people being defamed. Prominent people have been accused. Senator McDougall will be aware of this from his previous tenure here. Prominent people were accused of being involved in the most serious elements of child abuse. And that was published broadly. There has to be a consequence to that. And I suppose in this House we need to consider if we are dealing with the serious end of the range of defamation actions, well, what should be the remedy? And if we're talking about the serious end, we have to give an example of the serious end. And it's somebody being accused of very serious criminal wrongdoing when there was no liability on their part, in circumstances where the publication has been broadcast very widely. Let's say it's broadcast in a national newspaper or on a national broadcaster, and it's had very significant detrimental impact on the individual concerned. For instance, earlier on, Senator Mullen gave the example of Father Reynolds' case against RG. I would have thought that was an example of a defamation action at the very serious end of the range. And we need to recognise if that serious type of defamation occurs, there needs to be an appropriate remedy for the person whose good name has been severely damaged. That's why I am concerned, and I'm opposing the two amendments that are still subsisting, that from Senator Keoghan and that from Senator Cosgrove, because in effect what they're seeking to do, first of all in respect to Senator Keoghan's, is Senator Keoghan wants to put a cap on damages for a defamation claim, limiting general damages to €250,000. And subsection 2 indicates that there would be an overall cap of €400,000 that would apply to all forms of damages, with the exception of special damages. My concern about that is that it may not be permissible constitutionally, because we could find ourselves having examples of where somebody has been severely defamed and the court would turn around and say an award of that amount does not accurately reflect the damage done to the individual's good name. However, Senator Keoghan also talked about guidelines. We do actually have guidelines for defamation action at present. They're not in the same way as the personal injuries guidelines which were suggested recently, or amendments that were suggested recently. But in the decision of the Supreme Court in Higgins, they set out guidelines for appropriate awards of damages relating to general damages in defamation case. And it indicated that the presumptive upper limit would be €300,000. And in setting out that figure, the Supreme Court noted that while such cases would be exceptional, there would be cases in which exceeding that threshold would be warranted. What the Supreme Court did in the Higgins case is they set out, I think it was about 4 categories of defamation cases referred to in the decision of Mr. Justice McMenamin, where he said there's the minor defamation cases, and I think he said they should not exceed €50,000. In many instances they were much lower. But then he went to 2 higher levels and the highest level and set out grades, and generally the presumptive upper limit of the Supreme Court's ruling in Higgins is €300,000. The Higgins decision also went on to consider questions of aggravated damages. This indicates to me that there would be a serious cases in which the mandatory cap proposed by Senator Keoghan would be too low to sufficiently vindicate the right to a good name. Although those cases may be rare, we still need to consider them, and the state has a constitutional obligation to ensure that in those cases the individual impacted is sufficiently compensated and their reputation is sufficiently vindicated. The thresholds indicated by the Supreme Court in Higgins, although not identical, are within a similar range to the figures outlined by Senator Keoghan. As was the case in respect to Senator Nelson Murray's amendment, I believe that the Supreme Court's guidance, alongside the jury reform measures proposed by this bill, will provide courts with a flexible, sustainable and legally robust method of providing appropriate awards of damages in defamation. Proposed by this bill will provide courts with a flexible, sustainable and legally robust method of providing appropriate awards of damages in defamation cases. And I think that is preferable to a rigid statutory cap, which at best might indicate to individuals that awards of €250,000 to €400,000 are what to aim for in cases of defamation and have adverse impacts on the settlement of claims and alternative dispute resolution. So I cannot accept Senator Keoghan's amendment. In terms of Senator Cosgrove's amendment, she seeks to amend section 31, subsection 3 of the 2009 Act so that it provides that general damages in a defamation action shall not be presumed. A defamatory statement is defined in the 2009 Act as a statement that tends to injure a person's reputation in the eyes of reasonable members of society. Accepting Senator Cosgrove's amendment would amount to a legislative instruction to the court that in circumstances where a finding had been made that a person had suffered injury to their reputation, no damage should be presumed to flow from that injury. This severing of the link between injury suffered and damages awarded would be out of step with civil law generally and could be seen as an undue intrusion on the discretion of the court. It's also unclear what it would achieve. The 2009 Act already provides legislative guidance to the courts which requires them to have regard to the nature and gravity of a defamatory statement, among other factors. There is nothing in Section 31 which would prevent a court from finding that an injury to reputation had occurred, but that nature and gravity of the injury was such that only a nominal amount of damages was appropriate. The reforms to the role of juries provided for in the bill will also mean that the question of damages will be decided by judges who will produce reasoned judgments, setting out why the award of damages provided for is considered appropriate and proportionate, having regard to the guidance provided by the Supreme Court in the Higgins case. And for that reason, I cannot accept Senator Cosgrove's amendment. I think we have seen previously examples of where juries sometimes can give very large awards, or awards that are hard to explain, I suppose, to the parties before the court. One of the advantages of removing juries is that now a High Court judge who's awarding a significant defamation award will have to set out in the judgment the basis upon which he or she is determined that the award should be made at that level. It's also the case in the Defamation Act at present. There is a section that deals with damages, as I've just mentioned, and that sets out what the court's required to take into account in determining what damages should be awarded. Because it is the case that the primary remedy, although not the exclusive remedy, for those who have been defamed is an award of damages. But as I mentioned earlier on, there are other remedies available, such as correction orders, and they are something that parties should also be aware of as well. So unfortunately, I can't accept either amendment. Cairlig.
Anish, Section 17, Amendment 10A in the name of Senator Nelson Murray, withdrawn by leave of the House. Amendment 10B in the name of Senator Sharon Keoghan, new section already discussed with 10A. Is the section being moved? The amendment being moved?
I withdraw it.
Withdrawn. Withdrawn by leave of the House. Is that agreed? Agreed. Amendment 10C in the name of Senator Cosgrove, Harman, Stevenson and Noonan, new section already discussed with 10A. Is the amendment being moved? Moved. The amendment being pressed? Amendment being pressed. The question is, the amendment be made? Those in favour say thaw. Those against say kneel.
Yep.
I think the question is defeated. Vote on. 10. Anish, Defamation Amendment Bill 2024, Committee Stage Amendment 10C in the name of Senator Cosgrove. The question is that the new section be there inserted, and on that question a division has been challenged. Tellers, Thaw, Senator Cosgrove and Senator Harman, and Neil, Senator Garrett, Ahern and Senator Daly. The voting interval is 1 minute. It will be conducted electronically. It starts Anish.